Namaste and a warm welcome to this new episode on Directors' Criminal Liability. I am Sushila Ram Varma, Chief Consultant at the Indian Lawyer and Allied Services. The first question that would arise is, who is a director? A director is an employee or a person who has been appointed by the Board of Directors and who is in charge of the functioning of the company and looks after the affairs of the company on a day-to-day basis. Directors are very often known to be trustees of the company or as agents of the company that act on the behalf of the principal, which is the company itself. Directors must always act within the framework of the company's rules and regulations, namely the memorandum and articles. Over and above that, they must always act within the scope of the business of the company, failing which they might be held personally liable. Any director who acts beyond the scope of his services can be held liable under different types of laws. This could be under the Negotiable Instruments Act, under the labor laws, under the Goods and Services Act or the Income Tax, under the Information Technology Act, and these are only to name a few. Directors have to fulfill their duties and responsibilities under the different acts if they are mandatory. Failure to do so will attract criminal as well as civil liability. Directors are considered the will and the mind of the company. They also have a fiduciary duty towards the company. By fiduciary duty, I mean that they cannot act in a manner that will harm the interests of the company. Directors are known as officers in default. This would mean that if a director discharges his duty in a manner which is not in accordance with law, he would be deemed to be an officer in default and would therefore attract punishment as well as a fine. The one thing that all directors must be wary of and must be careful is that there can be a criminal liability foisted on a director if he fails to fulfill his or her obligations as per the law. Now, coming to the aspect of when can a director be held to be criminally liable. Generally, a director would be liable if he is involved or has acted in a fraudulent manner. A director can also be liable if he has breached his fiduciary duties, that is, he has acted in a manner that is not in the best interest of the company. This would make him liable for both penalty as well as prosecution. Tax evasion is another very important aspect where directors can be held to be criminally liable. This would be in cases where the company has evaded in paying taxes or has not paid their taxes fully. In such a case, it is always the directors who are held to be responsible. Another very important area is negligence. All directors are expected to act with reasonable care and skill. Any failure to do so would be deemed to be negligence, which is an offence punishable both under the civil as well as the criminal law. Directors are deemed to be personally liable in the following events, which are mentioned in the slides below. Probably one of the most important aspects of being a director is to be very careful about performance of their duties. There are many acts which have very stringent provisions, such as the Indian Penal Code, the Information Technology Act, the Money Laundering Act, the SEBI Act, which casts upon a special responsibility on all directors while performing their duties. Hence, we advise all directors to please be very careful before taking up a directorship of any company. If you have taken up the directorship of any company, please be aware of all the responsibilities that have been cast upon you. And it would also be good that one should consult with the lawyer from time to time to understand some of the stringent laws and the repercussions in case you as a director fail to fulfill your responsibility. However, a director is not always held to be responsible for his acts and omissions if he has done them in good faith. There are instances when courts have let directors go off the hook because they have realized that the director has not acted in a manner that was going against the interests of the company, though his act may have resulted in some loss to the company. However, a small word of caution, as directors are known as the alter ego of a company, that is, a company cannot function without the mind or the alter ego. All directors must be watchful of the fact that when they are performing their functions, they do it within the four corners of the law. Since this topic is very wide and it is not possible to cover everything in such a short video, we are open to taking any questions from directors who are involved in situations where they need legal advice. If you have liked our video, please like, share and subscribe, and we shall be happy to make more videos with such information. Thank you and have a good day.